That's a helpful clarification. I'd like a similar clarification. Thank you. With respect to individuals, I've heard and listened to your argument and read the briefs, and I think I understand it. But how does it fit in your mind with offended observers standing under the Establishment Clause, or some injuries about I access a park and I like to look at it in a certain way, and those kinds of injuries that the court has sometimes recognized and other times cast doubt on?
So it's true, I think, that there are different strands of this court's precedent, and I would put the Establishment Clause precedent and First Amendment precedent generally in its own buckets, because the court has sometimes recognized different theories in the First Amendment context.
Back on that a little bit, because standing is standing. It's Article 3,
yes,
right, that we're interpreting here. And so I think we've got to find some way to stitch it all together, and I'm looking for guidance from you.
So I think the way to approach this is to, if you're going to recognize some kind of offense or distress type of injury, to recognize that there
Should we?
Well,
I guess this is a preliminary.
No, I mean, I represent the government, so I think that kind of theory of injury would likely go far too much in the direction of allowing Article 3 courts to weigh in based on generalized grievances. But I guess what I would say is to distinguish the cases where this court has sometimes found that type of injury cognizable. Generally, it's in a situation where there is a kind of direct governmental action producing that type of injury. And here, our argument is that the FDA's actions in approving Mifepristone, specifically in 2016 and 2021, if you're looking at that, which was an incremental change, is so far upstream of the downstream assertion of harm or distress that the respondents are asserting that there is, just as a matter of law, an attenuated link here that cannot suffice for Article 3 jurisdiction.